I'll start out by introducing myself. My name is Eric Lee with Equity Real Estate, and this training program is one that I've created for you guys to cut through all the mystery of what it takes to do business. I've tried really hard to give you real life information. Today is actually, I'll jump right to our first thought here that will start us off. Before I do that, let's give a shout out to Guaranteed Rate and George Coleman for being a sponsor of this program. And if you want to refer to this later on, rather than taking notes or something like that, you can go to Elite Agent Training. Now, the quote that I want to start out with comes from Jim Rohn. Life in all its uniqueness would not be life without the negatives and the positives. That is why it is important to be a serious student of both. Today we're going to be a student of some of the negatives, the common pitfalls that real estate agents get into and how to avoid them. Now, I realize this goes out to agents all over the country. I'm focusing on some challenges, and I'll give you case examples from here in Utah. Our law may be a little bit different than your law, but most of the time the things that I talk about will apply to you just as well. If you don't think it does, please type in the comments and let me know, or type in the question panel and let me know if things are different for you so that I can read that in case there's others on here from your state. Or if what I say raises a question in your mind, then please feel free to contact your broker for clarification on anything. But what I'm going to be covering today should be generic enough as far as common pitfalls for it to apply to all agents. All right, pitfall number one is implied agency. This one comes up a lot. Agency by implication occurs when an agent acts in the role of an agent, whether a contract for agency exists or not. In such an occasion, the agent may also have full liability in the transaction. So I remember years ago reading in our division newsletter. Our division of real estate in Utah sends out a quarterly newsletter. It's kind of our walk of shame. And what they do in there, they've got articles and stuff about changes to the law and things like that. But at the end of the newsletter, they focus on agents that have run afoul of the division of real estate. There's been a complaint against them. The complaint has been verified, and it tells you the penalties. And we're actually going to see several of these today because it is public record. So I've copied and pasted and put it on here so that you guys can see that these are real fines. Agents are getting into sometimes some pretty serious trouble. So anyways, years ago, I had read the story of some lady that had helped her friend out. Her friend had been selling a home herself. She didn't know where to get paperwork, so her real estate agent friend said, well, here's some paperwork. And that was the extent of what she had done. That lady, apparently the deal went south. There wasn't really a real estate agent involved. And so there was some confusion. People started to sue each other. And in the course of the complaints that were issued, somebody mentioned this lady's name, that they'd gotten the paperwork from her. So she got a call from the Division of Real Estate and said, hey, you were involved in this transaction. She said, oh, no. That was just my friend. I just gave her some paperwork to help her out. I wasn't involved in any way. I didn't have agency. We hadn't signed an exclusive right to sell listing agreement. And the division said, you don't realize that by giving her paperwork, you created agency? They said, you do have liability. You have responsibility for this. And they gave her a fine for giving paperwork to her friend. She was fined and forced to take some courses on education. So pitfall number one, helping a friend or family member by providing forms. That's the example that I just gave you. We like to be helpful. Everybody likes to feel valuable to their neighbors, to their friends, to their family members. They know that you're a real estate expert. You want to feel valuable. Sometimes you feel like a prude saying, you know what, I can't cross that line. I can't help you unless we have agency. Here's my thought on that. And I've had several real life experiences with this. My own mother, who I love very much, my mom and dad are wonderful people. They retired from Las Vegas, where he taught school, and moved back here to Utah. They started looking around at different homes. They called some for sale by owners. And then it dawned on them, hey, at this point, let's see, I think 3 or 4 of their children. I was the first one to get into real estate, but I got most of my siblings into it. So this time 3 or 4 of us are real estate agents. And they called me up because I had the most experience maybe, or I worked in the area they were looking, and they said, hey, we want you to help us out. I'm like, fantastic. I will. And I just thought, you know, I'm going to follow my own training. I'm going to sit down with them. I'm going to tell them everything that I do. And so I did. I sat down with them and I said, here's what I do, and here's the form I need to sign the exclusive buyer-broker agreement. And they said, well, we've talked to a couple for sell by owners. How does it work with that? I said, no problem. I'll negotiate a commission. And they said, well, they told us they didn't want to pay a commission. So is it okay if we have you help us with listed properties, but if it's not listed, then you don't help us? And I said, no, that's not okay. I won't jeopardize. See, I've got a wife and 5 kids. And to me, that's my primary responsibility. Love my parents, but my wife and 5 kids are the ones I've made the promises to that I'm going to provide for them. And if I put my license in jeopardy by providing agency without representation, without real forms, then I've jeopardized my primary responsibility. And so I said, Mom and Dad, I can't do that. I don't think it's in your best interest. And they said, well, we can't be committed. And I had to be strong enough to say, okay, I understand. I don't have any hard feelings. I didn't have any hard feelings back then. I just hoped that they didn't get harmed too badly by representing themselves. So you have to draw a hard line. And I know you want to be helpful, but if you really want to be helpful, you have to be in all the way. Giving them some forms that they don't know how to fill out. I see forms come in from agents that are filled out incorrectly every day. All right? Imagine giving those to somebody that didn't have any education, that doesn't have any idea of the possible consequences of filling them out incorrectly. You're not helping somebody by giving them information halfway. You're just letting them get into possibly more trouble than they could have without you. So if you're going to help somebody, help them all the way. Get agency signed and help them. Showing homes without an agency agreement signed. Now this one's a little bit tougher one. If I'm the listing agent and somebody calls to see my home, I have to go show that home. Whether they're represented or not, I've got a fiduciary duty to the seller to show that home. Okay? But what if a buyer calls me? And this has happened so much in this last year. I've had so many people call me up. I'll give you an example from just last week. Somebody called me up and said, hey, we found this home on your website. We'd like to go see it right away. I'm like, fantastic. I'd love to show it to you. When are you available? I found the time and everything. I said, oh, yeah, one last question. Do you have an agent that you're working with as buyers? Well, no, not really. And I could tell there was some squirreliness there. And I said, if you did find a home you would like, do you have an agent that would write up the offer for you? Yeah, we've got a close friend that would write it up for us. So this time I said, and it wasn't my listing that they had found on the website. It was from another brokerage. Wasn't even one of my brokerage's listings. So this time I said, you know what? You'll need to call your agent. I'm not going to meet with you to show you a home when you have another agent you plan on writing up an agreement with. And they said, are you serious? I said, yeah, I'm very serious. It creates some liability for me. And if you've got an agent that you're going to be giving the commission to, he should be here earning the commission. And they said, their response was this: we have had so many agents show us homes. Nobody has ever said they wouldn't to us before. And I said, well, I have probably more experience than all your other agents combined. And that's not being full of myself. I supervise 160 agents and have done for nearly 10 years. It gives me a lot of experience seeing bad things happen to agents. And so I did. I just said, you know what, I've got a lot of experience. I've got more than most agents do, and I won't compromise myself in that way. I'm sorry. If you've got somebody that you're going to be working with, they need to work for you. And good luck. And I hung up on him. But I don't go out and I don't work for free. I do. Every time somebody calls, I ask if they have an agent. And this year, more than ever, I've had people call that want me to work for them and not write an offer because they have somebody else that's part-time or whatever that they want to give the money to. I don't work that way. Again, if it's my listing, I need to do it because I've got a fiduciary duty to the sellers. But if it's not my listing and they call off my website and it's some other company, then don't compromise yourself, okay? Another one is this: assisting a seller with paperwork in an MLS entry only or a fee for service situation. Now what this is, and this comes up all across the country, there's a seller out there that decided they didn't want to pay a full commission. Okay, they wanted to save some money. They maybe tried it for sell by owner and that didn't work. So they got online and they found a really cheap agent. He said, you know what, I'll put it on the MLS for you for a flat fee of $500. So you pay that agent $500 up front to put it on the MLS. He doesn't care if it sells or not. He's not involved in the paperwork. In some states, Utah has a minimum service statute that this actually violates, but we won't enforce it because the federal government has actually come to our state, and I've seen the forms that they sent, the letters, basically veiled threats saying that, hey, this is a free market, and if you guys try to limit the free market with your state law, we will come down on you hard. So our own state has a limited service requirement saying that if we take on a listing, we have to have all the paperwork come through us, we have to do the negotiating, et cetera, et cetera, et cetera. And that's really the big stuff. We have to have the offers. We have to help negotiate. That's basically it. Make sure that the final numbers are correct when they go to closing. That's our minimum service requirement. And yet there are companies that won't do that. They'll just put it on the MLS. And then if you want help with paperwork, you have to pay an additional fee. And that's a violation of our state law, which our own state won't enforce because the federal government has said that that limits free enterprise. Okay? So let's say that we do have a fee for service or an MLS entry-only situation. We're the buyer's agent bringing a buyer in. The seller doesn't have access to the correct paperwork. We're going to be providing the purchase contract, but what if they want to counteroffer us? Or what if they do accept our offer and they want to provide us with seller's disclosures, which our paperwork, our purchase contract requires seller's disclosures, and yet that's a copyrighted form for the Utah Association of Realtors. How do they get those disclosures? Well, if our agent gives them the forms, then it could almost be construed as implied agency. Now in Utah, we actually passed a law just last year that protects our agents from this, but not all states have something like that. And so how do you protect yourself as an agent when you're dealing with somebody that is they're represented in a very limited way? And in order for you to get the transaction through, you're going to have to be doing a lot of the job as a listing agent. Okay? We're going to talk about that a little bit. I want to show you, actually, let's go ahead and talk about how to do that right now, and then I'll show you some of the penalties that can come about. Again, in Utah, we've just passed a law that protects us for this. If I'm dealing with somebody like that, though, what I'm going to do is I'm going to have them sign a for sale by owner commission agreement. The reason why is, at least in our form, and you'll want to see if you have a form like this provided by your state board of realtors, but our for sale by owner commission agreement states that to the extent that I need to help my client by providing paperwork to the other party, I can do that without creating agency. And even though they're not a for sale by owner technically, functionally they are. They're acting like one. They're doing their own paperwork. So I have to help them out. And so a very simple fix is for me to have them sign a for sale by owner commission agreement. That just states clearly what the working relationship is. I'm representing my buyers. They're representing themselves or somebody else. And that way I can protect myself. Let's look at some of the penalties that happen from this. And again, these are real names for real people. And again, this is public record, so I'm not hurting anybody by saying this. This is all public. So Vicky, a Washington sales agent, in a stipulated order dated November 19, 2014, she admitted to several violations over the course of 15 transactions. The violations were failing to execute written agency agreements. Now, how does this happen? I have buyer's agents tell me all the time, oh, I don't get a buyer agreement signed unless we're making offers. That is not what the Code of Ethics says for us to do. It's not what our state law at least says for us to do. We're supposed to have written agency agreements up front so that all parties understand how this deal works. Okay? Failing to obtain written informed consent required to represent both parties to a transaction. So now she's doing limited agency situations representing both sides without having limited agency form and utilizing outdated listing agreements. Ms. Wiley agreed to pay a civil penalty of $10,000, 20 hours of additional continuing education, and her license placed on probation for a year. Okay? Here's another one. This is a principal broker, which scares me a little bit. Mr. Barker admitted to having failed to exercise active supervision over the conduct of a licensee affiliated with him, having failed to maintain and safeguard documents, so his record keeping was poor. Now, by the way, with equity, if you use our systems, our record keeping is exceptional. If you're using this new .loop program, which you should be doing, you're very, very well protected because every new iteration of a document, somebody added this, it shows that that was added and it's separate. If you use these forms that we provide you and the systems that we provide you, you're very, very well protected. This guy didn't. Having failed to obtain informed written consent in order to represent both principals in a transaction as a limited agent. So again, a limited agency situation, he had to pay a $20,000 fine, 8 hours of continuing education, 4 hours of mandatory training. Okay, these are serious fines, $10,000 and $20,000. Your spouse is not going to be happy if you come home and say, hey, guess what? We don't get to buy a car for another 5 or 6 years because our savings just got blown. Okay, written agency. This is January of 2014. Ms. Fry admitted to violating Utah law by assisting a buyer with the purchase of property without first obtaining the required written agency and by drafting a legal document instead of using a state-approved form or a form prepared by an attorney. So she did two things wrong. She went and helped a buyer without first having written agency. I know agents that do that all the time, and they defend it. They not only do it, they think that it's right. They think that it's somehow honorable that, you know what, I don't require this of my clients because I've never been stabbed in the back and I just provide a really high level of service. Guys, if you're violating the law, it's not a high level of service. Okay? You think that it's just about getting stabbed in the back or something. It's not. It's about so much more than that. Clients have the right, and it's a legal right, to know exactly what their working relationship with you is up front. All right? This should not be a surprise to them that they're going to have to end up paying a commission, or if it's working with a buyer, and even though the seller's paying the commission, none of this should be a surprise. They have the legal right to know all of this up front. And then Ms. Fry also was she drafted her own documents, which is simply a case. That sounds really bad, like she's creating all this legal language. I see agents do it all the time simply because they don't know there's a form already available to you, created by your state board of realtors, that solves that problem, but you don't know about the tools in your own toolbox, so you go make up your own language, which does not adequately cover the situation. There's loopholes in it. You're not an attorney. You don't understand how to write it. We're only licensed to use the forms that are created for us. All right. So here's how to protect yourself. Always sign an agency agreement up front, especially with friends and family. Treat them the best way that you could treat any of your clients. It only makes sense they're friends and family. Treat them the best. And that means have them go through your presentation. Whether that's dependent on hiring you or not is irrelevant. Going through your presentation, listing and buyer presentation, lets them know you're a professional. It's the highest level of service that you've devised to take care of your clients. Deliver that same high level of service to friends and family. Don't cheat them. Okay? Once you've delivered that presentation, have them sign an agency agreement with you. If they won't, don't jeopardize your family for somebody claiming to be a friend that wants you to work for free. Not only wants you to work for free, but do so at the jeopardy of your job, license, and financial, because you could get some serious fines. When dealing with a fee-for-service agent, make sure you have a form signed by the seller disclosing agency. We've talked about that. And if you do deal directly with a client because a fee-for-service agent says, you know what, you just talked to them directly, they didn't pay me to do that part, then get that in writing. get an email from that agent giving you permission to interact directly with their client. And that should protect you pretty well if any claims are filed later on that you overstepped your bounds. Okay? Here's one on limited agency. Ms. White admitted to having failed to provide her client a limited agency agreement prior to submitting an offer on a property listed with another agent from her brokerage. So this time she's not representing both parties. She's not representing the buyer and the seller, but another agent in her brokerage is representing one of them. Now in Utah, and depending on how big you are in other states, I know Colorado's getting pretty big as well, if you're an equity agent in my office and you make an offer on a home down in Salt Lake or even St. George in a completely different office, the other end of the state, we're both equity agents and we're all under one principal broker in the state of Utah. There's 13 different branch brokers, but one principal broker. And so if you're making an offer anywhere in the state of Utah with another equity agent, you have to have a limited agency form. And if you don't, it could cost you $500 and possibly some continuing education requirements. All right. Let's talk about the big pitfall number 2, handling other people's money. This one will get you in trouble almost quicker than anything else. They are very, very strict about how you treat other people's money. We're going to talk about when to collect it, where to deposit it, and what happens if it bounces. So first of all, when to collect. On your purchase contract, it says when you're going to collect the earnest money. So if I've checked on our purchase contract, it says I'm either collecting it right now or I'm going to collect it within 4 days of acceptance. All right? So I usually do the 4 days of acceptance that I'm going to collect it. Now, what happens if I fail to collect it? My duty is, it's called an affirmative obligation. That means I don't have to wait for somebody to tell me. I don't wait for the other party to discover that it's not there yet. I have an affirmative obligation. I need to step forward and say, look, the 4 days have passed. My client's out of town. I don't have the money. Now, what does this do to your contract? Well, it makes it voidable. Mind you, that's not void. It's not automatically voiding the contract, but it does make it voidable. The seller can say, you know what, you guys aren't serious. You've already not fulfilled the very easiest part of this contract. We're going to go ahead and cancel it based on non-performance on your part. They could do that. Or they could say, well, when do they get back? It's going to be 3 days. We'll give them 3 more days to get the money in. But you as the agent can't sit on that information. You have to affirmatively go tell the other party, I didn't collect the earnest money. Now, where do you deposit it? With equity, we have the policy that earnest money goes to the title company. We do that for a couple of reasons. Internally, it makes managing our books much easier. I know that doesn't matter at all to you, but what does matter to you is that if the title company has all the money, when the deal funds and records, they can wire all of that money directly to payroll in one thing, and payroll can then wire it out. They don't have to wire the money from that and then us send them some other money, and it basically trims a day or two off of how quickly you get your paycheck. And that's what most of our agents have told us. Well, almost all of them have said, we would like our money more quickly. If we can get it in less than 24 hours, that's ideal. And that's what we've delivered. So we deposit our earnest money with the title company. Now, that comes with some special requirements. And there's reminders of this to you all throughout your listing packet, your buyer packet. All of this is detailed out there, but I'm going to reiterate it here for you. When I collect earnest money and deliver it to a title company, my purchase contract doesn't state that. Our purchase contract has a default statement that says the earnest money is going to go to the brokerage trust account. Now all of a sudden I'm not putting it there, so I have to add language in there. I can add an addendum that very easily that just says earnest money to be deposited with XYZ title company in accordance with state law. That's it. Both parties sign it, they agree to it, and nobody really cares. And if somebody does care a lot that, you know, this has to be in a brokerage trust account, we can either educate them, or we do have a trust account because we have to by law, and we could keep it there if we need to. Mind you, there could be some delays later on your payroll. I've got a comment typed in here. Okay, somebody lost sound. Did anybody else lose sound? let's put it this way. If you can still hear me, will you click the little webinar dashboard button that looks like a hand with an arrow on it? Okay, looks like we've got sound back. All right. Hopefully that was an isolated incident. So we're going to deposit our earnest money with the title company. We're going to add an addendum that states that it's held with the title company. Now I'm going to share with you a little trick, and I've ran this past our attorney, and he thinks it's a brilliant idea. I don't ever touch the earnest money. I state in there it's going to be delivered within 4 days of acceptance to the title company. Once we get it accepted, one of my standard procedures is my assistant emails my client and says, congratulations, we're under contract. We have 4 days from this date to get the earnest money turned in to the title company. Here's a list of their addresses. And I like to use some of the bigger local title companies because they have 8 addresses all up and down the Wasatch Front. And that makes it very convenient for my client on their way to work, on their way to the grocery store, to drop off their earnest money directly to the title company. Now, I've never handled it, which is fantastic for me because I'm not going to get in trouble for it. And my title officer, I'll have my client tell me which location they're going to drop it off at. I tell my title officer that, and so if it's not her office, she'll contact that office where they're dropping it off and say, hey, expect a check for me. Then she gets it, and guess what she has saved on her computer? She has my equity earnest money receipt form. And so she's got that saved. She prints it out, fills it out, signs that she's received the earnest money, and she sends that receipt to me. So the contract says it's going to be delivered to the title company. I've got a receipt saying it was. I send that receipt to the listing agent, and he knows that we fulfilled the contract just like we said we would. And through it all, I never had to handle the earnest money. I didn't risk losing the earnest money, and I didn't waste my time trying to collect it. And honestly, the title company's there open all day long. It's probably been much more convenient for my clients as well. The last question here, what happens if that earnest money check bounces? Again, we have that affirmative obligation. The title company, if they've deposited it, they're going to let you know right away, hey, this check bounced. As soon as you find out that that has happened, you need to alert the other party. So you're going to call up the seller's agent, and you're going to say, look, just got news that the check bounced. Their payroll hadn't hit yet. They've got their payroll in now. We're going to get a new check in, but I wanted to let you know. Okay, we have to let them know. Even if we do have a backup plan of getting a new check in and deposited right away, we have an affirmative obligation to let them know our earnest money check bounced. The only time we don't have that affirmative obligation is, let's say I again have 4 business days to get it in. Let's say my client gets it turned in the very first day. By the second day, title company calls me and says, hey, this bounced. By the third day, my client's got a new check in that clears. All right? I've still met my obligation of having it in within 4 days. I don't need to alert anybody because I've complied with my duty, and we've complied with the contract. All right, but otherwise, we have to let the other party know. You can't hide this kind of information. Even though hiding it might be beneficial to your client, it is not dealing in good faith. You have to do it, okay? All right, pitfall number 3, expiring licenses. This one is simple if you maintain it, if you stay on top of it. Now, every state is different, so hopefully you know how it works in your state. In the state of Utah, we have an online system. We go to the Division of Real Estate's website. They have a little button there called RELMS, Real Estate License Management System. Everything is done online here. And so I log into RELMS, and right there I can check how many CE credits do I have. And it has it in a couple of paragraphs. It says every 2 years you're required to have 18 hours of continuing education. 9 hours of it have to be core credit. The other 9 can be whatever. And then it lists all the classes that they have you registered for. So if I took a CE class on Tuesday at my office, by Thursday or Friday, I'm logging in to the Division of Real Estate's website, to my Real Estate License Management System, and I'm verifying that I got credit for that class. because the instructors have to post those attendees' records onto that division's license system. Okay. Now let's say that I didn't get it posted and I didn't stay on top of it, and I've let time slip by and I get a notice that, wow, my license is about to expire at the end of the month. I've got 3 weeks left and I've got 18 hours I have to get in. I think I've taken some CE classes, so I log into my license management system, and guess what? They don't have a record of any. Well, you could try to go back at this point, try to call instructors, see if they have records. That, in my opinion, is a losing battle. You're probably not going to get anywhere with that. So trying to cram it in is tough, and it gets expensive, because although we provide CE classes almost every week at my office that are free, if you need to get 18 hours in 2 weeks, you got to pay for them, and they're not cheap. So the Division of Real Estate says, look, we give instructors a couple of weeks plus our own systems. They don't update overnight. The only way that you can guarantee to have that done is have everything done 2 weeks prior to your license expiring. And so if it's the last week and you're on the computer getting your CE classes in, there's a good chance your license is going to expire. That means you can't get paid. Any listings have to be taken out of your name. You can't show homes with clients. You don't have a license. So don't do this. There are very serious fines and penalties for agents operating without licenses. And the fines get even worse for brokers. And so we have to take aggressive steps, removing your listings from you. We can't just be like, oh, I understand and everything. The division can audit the MLS. If your license is inactive with the division and you've got active listings, then the brokerage gets in serious trouble. So we have to take proactive steps and actually remove your listings out of your name. Okay? And it doesn't sound fair, but if you stay on top of things, it's not an issue, and it's very easy to manage. So make sure you're aware of that. All right, pitfall number 4 comes in a lot of different forms, different money problems. Okay? Working with builders, that's our first one that we're going to discuss today. When I work with builders, most of the time they don't list all of their homes on the MLS. Now what that means is that I don't have any agreement in writing that I'm going to get paid, because the MLS is what tells me I'm going to get paid, because they post right there, you're going to get paid 3% gross commission on the sale of the home. And so the builders only put one home on there. It's their model home that they've put onto the MLS, so it comes up in people's searches. That gets people out to their neighborhood, and then they sell them a different home that never was on the MLS. So how do you get paid? Well, you have to get a separate brokerage commission agreement signed by that builder. And I had a builder once I met with, and I asked them for this form. They said, oh, don't worry about it. You're listed as the agent here on page 2 of the purchase contract, so we know that you're representing them. And I said, hey, that's all fine and dandy. You know I'm representing them, but nothing in the purchase contract says I'm going to get paid. And since you're not on the MLS, I have to have this separate form. And what eventually happened is I had to go to my clients because they would not provide me with that form. I don't know if they were trying to be squirrely with it, pull a fast one. I don't know, but they didn't sign it. And they didn't sign it, and almost a month passed. And I went to my clients and said, hey, clients, you're on the line for this 3% if these guys don't sign it. And I haven't been able to get them to. So if you could put some pressure on them. And my clients raised hell with the builder and said, look, he's been a great agent for us. He helped us sell our home. You need to get that form signed for him. We are not going to pay that 3% commission, because I had a buyer agency agreement signed saying that they would, unless it was paid by the listing brokerage, in which case it satisfied it. So my clients had to get involved. Just be aware of how commissions work, okay, how the money works. If it's on the MLS, the rules of the MLS say that they will pay you what they've stated they will, and the MLS will enforce that, okay? If it's not on the MLS, you don't have anything saying that you're going to get paid. I'll give you a quick example in a different board. Here in Utah, we've got our board, and our MLS is huge. There are other cities like Colorado. I think they have multiple MLSs within the one city. We've got one MLS that covers almost all of the Wasatch Front. But just over the mountain in Park City, they've got their own little board and their own little MLS. And so if they list something up there, and I go up there with a client to buy it, I could actually go through that whole process on a $2 million home, and they wouldn't have to pay me a dime because it's not in their MLS. And I've heard of this happening to agents. And there is no recourse because everything's got to be in writing, and you didn't have anything in writing. They could say, well, I thought your buyers were going to pay you. Your buyer's client, you didn't have any agreement with us, and a judge is going to back them up with that. Okay, there is no unwritten understanding anywhere. It's got to be in writing. And so if you're operating with a different board, get a brokerage commission agreement signed. Otherwise, or a different MLS, excuse me. Otherwise, they don't have an obligation to pay you. All right. When in doubt, write it out. This is just one. Agents call me pretty much every day saying, hey, how do I word this? And I said, well, what is your objective? And they told me your objective. I said, word it like that. Be absolutely clear what you're trying to get. Don't try to use a bunch of big fancy big words. Don't try to look like you're an attorney or something. Be clear as to your objective so that everybody understands it without misunderstandings. And again, don't get into creating your own forms. If your objective is addressed by an existing form available to you as a realtor, then you need to use that form. Okay? The only things that we're writing out are simple clarifications, things like that. All right? So, number one, be aware of the forms available to you. Number two, if you're not sure of something, spell it out in an addendum. Make sure that everybody's on the same page. All right, this next one. We've got a 3% buyer agent commission listed on the MLS, but in the comments, and I believe I've got a slide on this right here. This is actually one of our agents. He's a good agent, so I'm not saying anything bad about the agent, but you need to be aware of how this works. Okay, so he's listed down here a BAC of 3%, buyer agent commission of 3%. But in his agent remarks, he says, this is a short sale if seller's lender, as a condition of proving the sale, requires a reduction in the total commission agreed to a seller. Any such reduction shall be divided 50-50 between seller and buyer's broker. Very standard language. We see this all of the time. The problem is it's not enforceable. Okay, this is what's enforceable. And so I've talked with the MLS attorney, and he said, in his words, what the BAC giveth, the remarks cannot taketh away. I think that was his attempt at being biblical, kind of like a commandment. What the BAC giveth, the remarks can't take away. So how do you get around this as a buyer's agent or a listing agent if you're working a short sale where there is a chance that your commission could be less than 6%? You know, maybe they make it 5%, and so you want to pay 2.5 and 2.5. Down here on the BAC, you could put 2 to 3%, 2-3%, and then with the agent remarks, that clarifies that. But if you put 3% down here, you have to pay 3% in the end. Even if the other broker, even if the short sale approval came back with a 5% approval, you'd have to pay 3, and you'd only get to take 2. Okay. So, who wins? 3% wins. All right. What about this one? Getting paid directly by a client. So I've got a client, and this happens a lot actually with our agents. I go out, I show them a whole bunch of homes. We've seen 20 homes, okay, 25 homes. We've got a great relationship. They're very happy with me, and all of a sudden he finds out that, you know what, my job transfer just fell through. We're going to be staying here. We're not going to be moving. And so they come to you and they say, you know what, we are so grateful for your time. We're sorry to have yanked you around. We want to give you $500 to make it up to you. Okay? And so they write you out a check. Any problem with that? If you think there's a problem with that, click the little button that looks like a hand with an arrow on it. Raise your hand if you see a problem with that. Okay, good. A couple hands went up right away. I appreciate it. I'll go ahead and lower them. You can never get paid directly by a client. All payments to you as a real estate agent must come through the brokerage. Can your client write out a check? Absolutely. But they write it to Equity Real Estate, and then Equity Real Estate will pay you. Now in this case, they'd probably pay you like a referral or something. They take $150 of the $500 just to cover payroll expenses. Whatever we do, we come, with your broker's help, we had come to some agreement that was fair to you, covered our payroll expenses, so it's fair to us, but is still in compliance with the law. You can't get paid directly by a client. Okay, has to come through the brokerage, and again, we'll be fair to you. There was no file, so we're not going to take the $4.99 transaction fee that we would if we had to maintain a file. We're going to be fair. All right. What about referral fees? How much is too much, and does the form matter? Now, there's two different ways of looking at this. I could refer things to another agent. What is the standard? If you're a brand new agent, industry standard is 25 to 30%. Okay, so let's say that I get an internet lead, and I call up one of my agents, Mike, who's on with us today. And I say, Mike, I just got a lead. You want it? And he says, sure. I said, great. Are you okay with 25%? Or are you okay with 30%? And that comes out typically of the gross. So if I'm with a brokerage that takes a 50-50, or my starting brokerage was a 60-40 split. So if they take 40% of my commission, and I had to pay a 50% or a 30%, referral fee, then the brokerage takes 40. The referral fee is 30 of the whole. It's not 30 of the remainder after the brokerage takes their slice, and all I'm left with is 30. That's another great reason to be with equity real estate, because you can actually handle referral fees without getting screwed. You can actually come out of it with some money. So 25 to 30%. I'll see agents pay 50% for a signed agreement. So let's say I like working with sellers, but buyers are calling me all the time off of my listings, and I say, you know what? I'm going to change my business practice. I'm going to go meet with the buyers. I'm going to sign an exclusive buyer broker agreement, and then I'm going to, in effect, sell that to another agent and say, look, I've got a buyer ready to go. We've got an agency agreement signed. They've agreed to work with another agent. We'll put your name in the agreement, and you give me 50% for that. You can do that kind of thing. And there's agents out there all day that'll pay 50% for a signed client. All right, so that's one way of looking at referral fees. Let's talk about referral fees to clients. Okay, this is money problems that agents get into. Let's say that my client calls me and says, hey, my brother's going to buy a home. You've done a great job for me in the past. Give my brother a call. How much can I pay him? Now, this one, you have to go to your own state law and find out. In Utah, that's $150. All right? Does the form matter? I don't like to ever give cash, because we also have a law that sometimes conflicts with this. It says I can't have illegal sharing of commissions. And so if I wait to pay for that referral until after it's closed, which I do quite often, and I give him cash, that could be seen as an illegal sharing of commissions. So I'm going to have gift cards or something like that. They're as effective as cash, but it's not cash. So how much is too much? I can give the referring person up to $150. You have to see what it is in your state. Now, what if it's my client? So he referred me to his brother. His brother closes on the home, and the home didn't have a working refrigerator, and it's their first home. They don't have the money to have a refrigerator, and I said, you know what? I usually give my clients a gift. I'm going to give you a gift of a refrigerator. Okay. And is that okay? That's a pretty big gift. Even a small refrigerator is $1,000. So can I do that for my client? And the answer is yes. For my client, I can give them whatever I want. Now, we have in our Equity Archive a gift letter. If you're giving your client a gift, make sure that you use this gift letter, because that tells you the law, and it tells you what you have to do to make that legal. Number one, the lender has to know about it. Okay? If I'm giving my clients a fridge, does that trigger any alerts with the lender that would cause them to not give my client a loan? And the answer is usually no. Okay? They don't care if my client has a fridge. Can I give my client cash? The answer is no. Not unless the lender allows it, and the lender will never allow you to give your client cash. They don't allow buyers to close and get a cash gift for closing. Okay, so if the lender knew about that cash gift, They would not allow it. Your title company has to know about it. Or excuse me, not title company. Your principal broker, they've got to be aware of it, which if you're using the gift letter, then we're notified. So that's great. And the party paying the commission. So if I'm giving my buyer a nice gift, I have to alert the listing agent or his office that, hey, I'm giving my client a nice gift. They don't have to agree to it or anything like that. They just have to know about it. So if you're giving some nice client gifts, use that gift letter so that you make sure that you're in compliance with everything. All right? All right. This last one, I think this is our last pitfall we're going to cover today, is advertising. Mr. Booth admitted to having placed a sign for advertising the sale of property without having the brokerage name on the sign. In other words, it was a blind ad, and it cost him $500. Folks, if you've got an assistant, you're responsible for your assistant. Make sure that all of your ads have the name of the brokerage. Make sure that it's in compliance with the division's rules. Okay, in Utah, our brokerage name has to be 50% of the size of the largest print on the page. Now, this applies to every form of marketing that you're going to do. If you send out door hangers, the name of the brokerage has to be on there. 50% of the size is the largest print. If you send out, if you've got a website, the name of the brokerage has to be on there. Let's say that you've got a team name, you know, Your Home Utah. That's my team name, and I want to advertise that. I want to get that out there. That's not the brokerage name, though, and the division requirement is still the same. On that web page, it can be down at the bottom, but it has to be prominent. I've got the name of the brokerage, and it's 50% of the size of my largest print. Okay, so it doesn't matter the form of the advertising. If you're going to advertise in the newspaper or an online ad, the real estate name has to be there. Otherwise, it's a blind ad, and it can cost you some money. Okay, so folks, those were some of the most common scenarios that agents get in trouble with. Some of them, as you've seen, can be very, very expensive. Some of them are minor offenses, but nobody likes to give away $500 even for a minor offense. That's still a lot of money. So thank you for joining me. Thank you for being aware of these things and taking the time to try to improve your business. I hope you guys have a great weekend, and we'll see you online next week.